Rise.
Please be seated. Mr. Morrison, thank you very much.
I appear for Mr. Morrison.
And Mr. Morrison, you wish to swear an oath?
Yes, please.
If you just take the Bible and repeat after me. I, Nigel Morrison,
I, Nigel Morrison,
swear by Almighty God
swear by Almighty God
that the evidence I shall give to this commission
that the evidence I shall give to this commission
shall be the truth, the whole truth, and nothing but the truth.
shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Mr. Morrison. Ms. Thornton.
Morrison, you've prepared a witness statement dated 21 October 2021 in response to the summons you received from the Commission dated 8 October 2021. Is that correct?
That's correct.
And you have a copy of the statement with you?
I do.
And that's a document bearing number CRW.998.002.0969.
That's correct.
And is that your signature on page 25 of the document?
Yes, it is.
And the contents of your statement are true and correct?
They are. There's probably one thing I'd like to add, if I may, and that was after the resignation of Tony Corsanis at the AGM. I am now on the risk subcommittee of the board.
And is that referred to, is there a reference to the committee's, is there a particular paragraph you want to amend?
Let's see, paragraph 22, I think I said on the following Crown Resort Limited Board Committees, People and Remuneration, A, B, Audit and Corporate Governance, C, D. So probably we need to add E, which would now be the Risk Committee.
So commissioners will add subparagraph E to paragraph 22.
And just to clarify, that's as a member, not as chair of the committee?
No, that's as a member.
Thank you.
Commissioners, with that one amendment, I tender Mr. Morrison's statement.
The witness statement of Nigel Morrison dated the 21st of October 2021 and bearing the identifier number CRW.998.002.0969 with the amendment to paragraph 22 will be admitted into evidence as an exhibit. Thank you.
Thank you, Commissioner. Now, Mr. Morrison, you received regulatory approval and became a Director of Crown in April this year. Is that correct?
That's correct.
And as a Director, you're aware of the Crown's remediation plan?
I am.
Do you have any past experience of organisations going through a challenging period and implementing a remediation process?
I do.
And which organisations were they?
Well, there's probably a number that come to mind, but probably the one that's most relevant was when I joined Sky City in 2008.
So how do you believe your past experience can assist you as a non-executive Director of Crown to implement the remediation program?
Well, I think when I reflect back on 2008, 1st of March, when I joined Sky City Entertainment Group as the CEO and Managing Director, Sky City was not in a dissimilar shape to what Crown has been in over the last few months. And there was an acting CEO. The former CEO had been set aside by the board. There'd been a range of issues that the company was dealing with. There were accusations of loan sharking. The cultural issues in the organisation were very significant. There was a loss of confidence with the senior management throughout the organisation, probably a loss of confidence with the board. There was a view the board didn't act in a timely enough manner to address the cultural issues, and basically the whole organisation, really needed rebuilding, and frameworks putting in place, establishing new values, new remuneration systems. And I think it's fair to say within the first 3 months of my tenure at Sky City, we had changed about 80% of the senior executive team. and together with the head of human resources, if you like, and the new general counsel, both of those were new as I was, together we set about a program of reforming Sky City. And I think, that took some time and we worked our way through, but we made good progress and unified the organisation. And I think, going forward, then we were well in a position and we regained the trust of the regulators, of governments, particularly in South Australia. Sky City was not well liked in South Australia, and when I joined, and we set in train a range of initiatives to enhance that, and I think we were successful there. So much so that we ended up negotiating a range of investment transactions and expansions of the properties in Adelaide, Darwin and Auckland, working with governments and regulators. And I think by virtue of the fact, they trusted us to deliver on what we said we would deliver. And if they hadn't have trusted us, we wouldn't have achieved that. So we put in place a range of systems, particularly in relation to culture surveys and things like that, setting benchmarks and focusing on continuous improvement. And I think over a period of time, we significantly moved the culture of the organisation forward. And we measured that, and we could measure that down in some detail into the organisation. And we focused on remuneration being subject to not only financial parameters, but also non-financial parameters and various gatekeeper provisions as well to qualify for short-term incentives. So I think that was, there were a range of things there, not dissimilar to what Crown has been through. And I think that's been, that was a very relevant period of my my career.
Thank you, Mr Morrison. No more questions in chief.
Thank you, Ms Thornton. Mr Futrell.
Mate, please, Commissioner. Mr Morrison, my name's Michael Futrell. I'm one of the council assisting. Are you able to hear me clearly?
I can hear you. I wouldn't say it's the best clarity, but I can hear you.
Is that any better?
Probably, yes.
Right. Can I just start with the edit you made to your statement a moment ago, and you referred in paragraph 22E to the risk committee. Am I right in thinking that the full name of that committee is the Risk Management Committee?
I think that's correct, yes.
Right, thank you. It's the same committee of which Ms Holton is the chair, is that correct?
That's correct.
Can I take you to your statement, to paragraph 5 of your statement, and I think it makes a cross-reference to your the series of paragraphs that end up with your CV, and I just want to address some of your experience in the casino operational area. And I think you just outlined in your evidence in chief some of the activities when you were the managing director and chief executive of the Sky Entertainment Group. You were in that role between March 2008 to April 2016. That's correct, isn't it?
That's correct.
And am I right in thinking that Sky City is a New Zealand-based publicly listed company?
Its head office is in Auckland. It's New Zealand and Australia based, I would say. It's listed on the ASX and on the NZX. Okay,
and it operates casinos in New Zealand, the Northern Territory and South Australia?
It did when I was chief executive. It recently sold the Northern Territory casino.
Right. And before that, for about a year, you were the chief financial officer of the Galaxy Entertainment Group?
That's correct.
And Galaxy is a publicly listed company based in Hong Kong?
That's correct.
It operates casinos?
Yes.
Those casinos include casinos in Macau, is that right?
Yes.
What are the other jurisdictions that Galaxy operates casinos in?
Only Macau.
Only Macau. And how many casinos does it have in Macau? Or did it have in Macau at the time?
when I was there, it had one operating casino, and it was building what it called its Galaxy Mega Resort, which was my main area of focus as the corporate CFO. A major casino of, shall we say, Las Vegas standing in Cotai, a precinct of Macau.
Right.
It also operated some small, what they call city clubs, which were like what we would call here pubs and clubs.
Okay, and prior to that, between 2001 and 2006, you were the CEO of the Federation Group?
The Federal Group.
Sorry, Federal Group. That's a private company based in Tasmania?
That's correct.
And it operates the Rest Point Casino in Hobart?
It does.
And something called the Country Club in Launceston, is that a casino as well?
That's a casino as well, yes.
Right.
And it also operated a range of other businesses, tourism businesses, gaming businesses throughout the state of Tasmania.
Right. And prior to that, between 1997 and 2000, you were the COO of Crown Limited.
Yes.
And before that, the CFO of, between 1993 and 1997, the CFO of Crown Limited. At that time, was Crown Limited operating only in Victoria? Is that the case?
It was, yes.
So in effect, you were the CFO and then the CEO of Crown Melbourne. Is that the?
Yes.
So you've had, it's fair to say, a fair degree of experience in managing casino operations in the Asia Pacific area.
I think so.
After you left Sky City in 2006, what was your occupation between then and 2021?
I left executive life and I really was, I suppose I'd call it semi-retired.
Right.
And just looking after my own affairs.
And do you, other than the position you have on the Crown Resorts Board, do you hold any other positions at the moment on company or other governing bodies?
Other than my personal companies, no.
All right. Okay, so can I ask you some questions about the training you received on joining Crown Resorts earlier this year? And you've made mention in paragraph 34 of receiving some training in the area of RSG, which I take to mean responsible service of gaming.
Yes.
What was the nature of the training you received on your joining Crown Resorts?
Well, I think it's fair to say it probably didn't happen when I joined Crown Resorts. When I joined Crown Resorts, the organisation was somewhat of a state of flux. The CEO, Ken Barton, was moving on. The company secretary, Mary Manos, was moving on. So my induction wasn't as I would have liked it to be. But my training came about not really on joining, but during my tenure as becoming a director and while an observer, some online training sessions, some sessions from various lawyers, from talking to and presentations from executives in certain areas, from a handover, if you like, with Dr. John Horvath, who was the Director and Chair of Responsible Gaming Committee, and also Health and Safety. And then I've done, and then a number of sessions on AML and CTF, some with Steve Blackburn, some by Allens, and those sort of things.
All right, can I just stick with the RSG for the moment? In your previous roles in particular in the Sky City Group, was there an RSG program with that organisation?
Yeah, yes.
And are you able to draw any conclusions from your experience in Sky City and the observations about the RSG program with Crown Resorts to draw any comparisons between the nature of those programs?
Yes, I think so.
And what are your observations about the nature of the Crown Resorts program compared to, say, the Sky City program when you were there?
Well, I think with Sky City, we were working on two major transactions with the government in New Zealand and the regulators in New Zealand. On the one hand, being the development of the New Zealand International Convention Centre in exchange for a range of, shall we say, gambling reforms and increase in product and changes in the way the product worked. And we were doing a not dissimilar transaction with the South Australian government in relation to South Australia and building what is now the hotel that we built, the Sky City Hotel in Adelaide. And I think, New Zealand and South Australia in particular, the regulators and the government were very focused on making sure they had best practice harm minimisation measures. The Department of Internal Affairs in New Zealand and the regulators in South Australia. And so as part of those transactions, which took some years to negotiate, I might add, we focused and worked together with the regulators to make sure, I think, that we had very good best of breed practices in relation to harm minimisation and recognising, I would say to you, that it's not a science, but it does require a range of initiatives, and not all of it can be evidence-based. We entered into commitments to trial some things with the New Zealand regulator and agreed to other things with the South Australian regulator. And if I contrast that to Crown, I think some years ago, Crown was, I would say, best practice in responsible service of gaming. But I think probably over time it has slipped from that mantle, and there are some improvements that can be made to how Crown manages its responsible service of gaming, which we're focusing on as an organisation and keen to progress.
So is your sense that if Sky City was operating at best practice, Crown Resorts needs to lift its game somewhat to reach the same level as Sky City was when you left?
Sorry, I missed the last clause.
Are you suggesting that your impression is that Crown Resorts needs to lift its RSG program to the same level as Sky City's to reach best?
I think there are certain elements where that should be the case.
Okay, now, insofar as I take it you're familiar with the remediation plan that's currently in place at Crown Resorts?
I am familiar with the 73-page document, I believe, yes, to some extent.
So insofar as this matter has been addressed at the board level, do you understand there to be part of the remediation plan? It will cover RSG and bring it, as I think you said, the areas where improvement is required.
I think the remediation plan is a living document, but I think the answer to your question is yes.
Okay. And you mentioned that you had received some AML CTF training. I presume from your previous positions you would be familiar with the AML CTF Act and framework in any case.
That is correct. Having said that, I did leave Sky City in 2016, and while the Act and what was in place then, I think the perception of how casinos should have implemented and responded to the AML CTF matters at that time are somewhat different to what they are today.
All right. So just what was the nature of the AML and CTF training you received since you've joined Crown Resorts?
I can't remember specifically, but there were a number of presentations by Alan's going through the forms of crime that might be committed through through money laundering and the various transactions that we needed to make sure we were alert to, and the way the Act worked in broad terms, in terms of the levels of controls that needed to be in place, the monitoring of transactions, enterprise-wide risk management framework, and those sort of things, to make sure that we were compliant with the legislation in place.
Have you had any one-on-one sessions with Mr. Blackburn in that period of time?
I'm just trying to reflect whether they're one-on-one. I've certainly met with him in small groups, maybe 3-on-1. I've certainly met with him one-on-one, but probably not specifically in relation to AML, but certainly in small groups. And I should say we've now only got 3 licensed board directors, but I have had a number of meetings with Mr. Blackburn.
Specifically dealing with AML CTF risk, or more broadly?
In a group, he's made a number of presentations to smaller groups of us, specifically dealing with AML and CTF risk.
In paragraph 35 of your statement, you've indicated intention to undertake further professional development activities once time allows. Do you have any particular type of professional development in view, or is it a general statement you're making?
No, it's more a general statement. There's nothing that specifically comes to mind. The Board of Crown Resorts, as I noted, is currently in the process of developing a professional development plan for directors. So I'd imagine once that gets completed, then there'll be a number of things that we should attend to.
Okay, can I ask you some questions, broadly speaking, in the governance topic area, which is covered in your statement. The remediation plan suggests that there is an implementation of a centralised governance structure for the Crown Resorts Group.
Yeah.
Are you familiar with that?
Yes.
There is a suggestion in the current remediation plan that has been produced that there is some degree of reassessment taking place of the implementation of that centralised structure.
Right.
Okay. Are you familiar with any reassessment that is being undertaken of that centralised structure?
Not specifically, other than I would expect we would be waiting to see the outcomes, as we did yesterday, of the Victorian Royal Commission and of the Perth Royal Commission before we formalise the centralised or decentralised, or a blending of the two structures, to make sure we meet the requirements of the and announcements of the various commissions.
All right. Has, to your knowledge, any consideration been given at this stage to the question of whether a centralised structure is consistent with the regulatory framework in Western Australia?
I think the answer to that is yes. Consideration has been given to that.
And what is your view about whether the current structure, in terms of the way in which the licensee is managed in Perth, is or is not consistent with that regulatory framework?
My personal view is it is consistent, and I think it makes sense to have, and you could call it a centralised structure, or you could call it a structure where there are some shared services across the group, which allow for a better quality of service to be provided to the various arms. So I think it does make sense. I'm a supporter of a centralised function.
All right. Can I draw your attention to, it's not a question so much as a statement in, it's topic 23, and it starts on pinpoint 0981 of your statement where you've reproduced the topic. And it sets out in some length the somewhat complicated structure for the Perth Casino so you may need to refresh your memory because it is quite difficult to hold all of that in your head at the same time for the next series of questions I'm going to ask you.
Okay. Okay, you're waiting for me?
All right, so just if you can just try and remember that for a moment. In answer to a question that deals with that topic, following on from that topic, in topic 25, there's a question around the extent to which there's been any influence exercised over the Crown Perth entities, which is that group of entities referred to in that topic, by either Crown Resorts or Crown Melbourne. And in paragraph 65, you have in part answered that, and you made reference there to some shared service functions such as human resources and shared policies across the group, which I think you may have referred to a moment ago in answer to one of my earlier questions. Are you intending by that answer to that question to say that's the extent to your understanding of the degree of influence exercised over the Crown Perth entities, that is to say, through the shared service functions of human resources, RSG, AML, CTF?
No.
What?
I think, as I tried to say, in my view, the organisations work together.
How do you? In what way do you? Practically speaking, what do you mean by that?
All right. Well, so and I must admit, I confess I see it quite simply, perhaps incorrectly, but I see it quite simply. Crown Resorts Limited is the holding company. I see Burswood Limited as a subsidiary company, as is Crown Melbourne, as is Crown Sydney. Burswood is a wholly owned subsidiary of Crown Resorts, 100% owned by Crown Resorts. From the point of view of shareholders, the ASX, the auditors, it is regarded as a 100% controlled entity of Crown Resorts. It is consolidated into Crown Resorts. It's not equity accounted, suggesting that there may only be significant influence. It is consolidated 100% as a subsidiary. And so, obviously, Burswood has a range of obligations to the state. It has a privileged position of being a casino operator and has some fantastic assets. And Burswood, as does Crown Resorts, needs to be mindful of those and make sure that those responsibilities are dealt with in the best possible manner. And I think there is alignment in interest between Burswood and Crown Resorts. So I think, there is a strong degree of its control and influence over Burswood, but recognising the agreements it has with the state of Western Australia, its casino licence, and other regulations. And those things have to be properly considered and properly discharged, and make sure we do the best of our ability in doing those things. And that's not only on Burswood Limited, it's also a key criteria for Crown Resorts.
Can I just ask you, in the context of that answer in paragraph 65 of your statement, where you've referred to specifically RSG and AML CTF, we take those as two examples. Do you understand there to be any differences in either the RSG policies or the AML CTF program as it is applied to Crown Perth?
My expectation would be no. The AML CTF is national legislation, so it applies equally to all operations in Australia. And RSG, I guess, may be different in terms of the specific requirements in relation to RSG in relation to various government agreements, perhaps the state agreement or the licences or other acts which determine how the various casinos are required to operate. But my expectation is that all states want casinos to operate at a high standard of responsible service of gaming, and want all operators to be best of breed. So I think and if we're trying to achieve that, and I think you should also view the requirements of any state-based legislation in relation to responsible service of gaming. Ideally, it should be a foundational level, and the organisation should strive to be above that. So I do think what I would like to see is Crown get to a position of best of breed responsible service of gaming across all its gaming properties. And I would imagine there's a lot of commonality. There may be some modifications for specific state-based operations, but really I think by and large they would be absolutely minimal.
So in your conception of working together, do you understand there to be a mechanism or process by which Burswood Limited it has the ability to change or adapt group policies to suit the operations of Crown Perth?
Certainly, if it saw fit and it thought that needed to be done, then it should do that. And I would imagine the board of Crown Resorts would have dialogue with the board of Burswood and seek to understand, and if they were right, then it would be accepted, and there would be debate and consultation around that. And I think, you would get a better outcome at the end of the day.
All right. Do you have an example of that in your recent experience in Crown Resorts where that process has taken place, or are you now speaking of what your expectation would be?
I think probably it's what my expectation would be. I think, the Burswood board, to be fair, is going through a restructure with recent appointments. But I think what I can talk to you about is my experience with Sky City and the head office in Auckland and Sky City Adelaide. The executives on the Sky City board in Adelaide, there was a board in Adelaide, that was populated by executives of the organisation. There were no independent directors, there were no third parties. And in some extent, it was a weakness at the time when I joined Sky City that there wasn't an Adelaide board member on the Sky City board. We sought to address that, and we appointed an Adelaide-based board member on the Sky City Holding Company board. And so Adelaide had more of a voice, a vocal voice, at the holding company board. But I don't think there was ever any time, and there was never any view of the South Australian government, or for that matter the Northern Territory government, that there should be independent boards populated by directors who had no association with the holding company board. All
right, can we just come back and focus on Crown Resorts and Crown Perth, please? In paragraph 66 of your statement, you've referred to, and look at the last sentence here, Crown Resorts appoints the CEO of Burswood Limited with the consent of the Burswood Limited board.
Yes.
Who is it? Who are you describing there as the CEO of Burswood Limited?
Mr. Lonnie Bossy.
All right. So in other contexts, we've been referring to Mr. Bossy as the CEO of Crown Perth, effectively.
Okay, yes.
All right. And do you know, from your own knowledge, when he was appointed as the CEO of Burswood Limited?
I don't think it was that long ago, because he was previously the Chief Operating Officer. I'm guessing maybe it was a year, maybe it was in 2020.
It wasn't during your time on the board then of Crown Resorts?
My time on the board commenced in April. I think it was prior to that.
All right.
I could be wrong. I can't categorically answer that. But he's certainly been the most senior executive in Perth since I've been associated with Crown.
All right. So then the reference to with the consent of the Burswood Limited board, is that something from your own knowledge, or is it something that someone else has told you?
It's my understanding as to how the governance structure should work.
Well, should work or does work?
Well, I think going forward, in the recent past does work, but going back in the more distant past probably should work.
All right. Can I ask that you look at topic 26, please? And this question is directed to whether there is a degree of influence or direction of any of the Crown Perth entities has on the governance and operation of the other entities. So, in other words, the extent to which Burswood Limited, for example, may influence or direct the operations of Burswood nominees as licensee. As an example. Now, if you don't know, Mr. Morrison, you don't need to answer the question, but in your answer to this particular topic, you haven't answered that question directly. So, if I could just ask you, is there...
Okay, so from my point of view, I mean, probably naively, I would regard them, and I appreciate there are differences in what the companies do and how they work together. And in some sense, I guess, with the property trust structure and nominees holding the licence and management being the employee, it goes back to a former time and is somewhat of a legacy structure. And it's a legacy structure even before Burswood Limited acquired the property trust. And I'm not sure what year that was. It might have been in the 80s or 90s, but it was certainly before PBL acquired Burswood Limited. So the structure is a little bit of a legacy structure. But I think from the time that PBL acquired Burswood Limited in around 2004, the view was Burswood Limited was the company and it had different entities underneath it, which were the component parts of what you might regard as Crown Perth. And, being somewhat of a legacy structure through the trust and et cetera. But so my sense of it is that I don't know specifically the degree of influence or direction that those Crown Perth entities have on the operation of each other, but I treat them as a whole, and I see them as part of the elements that make up Burswood Limited or Crown Perth.
Okay, thank you, Mr. Morrison. I've got a couple more questions about this structural arrangement. In in paragraph 64, you've mentioned that the constitution of Burswood Limited is outdated and there's no charter, and you're aiming to rectify that. And similarly,
Yeah.
in paragraph 69, you've returned to a similar topic and made reference to some recent discussions and proposals. Could I ask that you be shown CRW.701.009.5375? Now, I don't know if you can recognise this this document, Mr. Morrison, given that it's entirely redacted.
Is it possible to blow up the top part? It's very, very small. That's better. Thank you. Go on, 15th October, Board Charter and Constitution, confidential and privileged. Thank you.
And I don't know if this has been reviewed by you recently as part of some board papers or not, but it may be the topic to which you've made reference in your statement about the proposed changes. Because if I take you to attachment 1, which starts on page pinpoint 5378, there's a draft of a charter. Is that a document of the kind that you're describing in your statement?
I think that's correct.
And when you say there's been, how if you like, how advanced are the discussions around the adoption of a charter for Burswood Limited?
There's been some work that's gone into it over the last, I would say, month, but I'd say it's still very much work in progress.
All right. Have there been any discussions around the composition of the ideal composition of the Burswood Limited board in terms of who should be members of that board?
Yes. Of Burswood Limited.
Burswood Limited. So if I just take you to pinpoint 5381 as an example, where there's a heading composition of board, and 4.1 refers to structure. As I read this draft, there must be at least 3 directors, consistently with the Constitution, and in E, at least one of those directors must be a non-executive director of Crown Resorts Limited. So at least one is both the director of Crown Resorts Limited and Burswood Limited. And over the page, there's a reference to another director being essentially this Chief Executive Officer of Crown Resorts. So at least in this draft, what is contemplated is that at least 2 of 3 members of the board must be either a non-executive director of Crown Resorts or the Chief Executive of Crown Resorts. To your understanding, is there any proposal, or is it considered to be part of any proposal, there should be a director, a mandated director that is independent of both Crown Resorts Limited Board and or the managerial or executive of Crown Resorts?
I don't think so. I don't think that's the case. And I personally don't think there needs to be. As I say, I think Burswood is a 100% owned subsidiary of Crown Resorts. And if I look at other models in South Australia and the Northern Territory, there did not need to be independent directors of subsidiary companies which weren't associated with the holding company. It does say a minimum of 3 directors. As I'm sure you're aware, Bruce Carter is awaiting probity, but I think will be the chairman of Burswood. Steve McCann is the CEO, so those 2 will be on the board, and Ms. Marina Fuster is a third of those directors. My personal view is that there should be, and I think Chairman-elect Ziggy Skowski indicated this, that I think it makes sense to have, and as I mentioned in relation to Adelaide, a Perth-based director on the Crown Resorts Board who also sits on the Burswood Limited Board. And I actually think that's quite important. But I do think they should be on the Crown Resorts Board as well as the Burswood Board. And I think, we did that in Adelaide, and I think that worked well. And I think, as Mr. Swikowski commented, we've recently gone from 3 directors in Crown Resorts and added on 2 more Melbourne-based directors to give Melbourne that critical mass, but they are not independent directors of the holding company. They are on the holding company board, but will also sit on Crown Melbourne. And I think we need to replicate a similar structure with Crown Perth. They should be on Burswood, but also on Crown Resorts Limited. And I think that would lead to a very, very good governance structure and add to the considerations of the Crown Resorts Board with the input from a local Perth-based director. And I think in times gone by, during my tenure, we have searched for a Perth-based director to join the Crown Resorts Board. But as you can probably imagine, with the Burgon inquiry and 2 royal commissions, it's not as attractive as it once was. So, but we would hope that, I would hope we would do that. And then I think we also need a new director in Sydney. And I would hope we do that as well. And that would be on the Sydney board of Sydney, but also on the Crown Resorts Board. And that would take us then from a total of 5 to 7 non-executive directors plus Mr. McCann.
Okay, can I direct your attention to the next page? So 2 pages further on, 5383, which is referring to the duties and responsibilities of the board members. And I think you mentioned earlier in answer to one of my earlier questions a concept of working together. That's to say, Crown Resorts Limited Board working together with the Burswood Limited Board.
Yeah.
And I just want to draw it, there's a paragraph that begins, subject always to the company's overriding duty to act in the best interest of the company. There's a paragraph...
sorry, where are we?
There's a paragraph...
Can you blow? Could I ask for that to be blown up? Just okay, thank you. Yes.
Is that consistent with what the view you expressed about the concept of working together?
Yes, I think so.
And again, just to pick up this concept, 5.4, the second bullet point on that page, there's a conjunction with management and in consultation with Crown Resorts Limited, establishing a vision and strategies for Crown Perth. Again, is that what you're meaning by working together?
Yes, I think so, and I think working together, the Crown Resorts Board, and particularly if we go down, the structure of Burswood, where we have a number of directors on Crown Resorts that are on the Burswood board, there should certainly be a commonality and an opportunity for discussion and adding value together. So yes, I think so.
Okay, I just want to take you to a draft of an amendment to the Constitution, which is attachment 2, starts on page pinpoint 5389. Again, I don't know how mature the discussions are, Mr. Morris, in respect to this, whether there's been some debate about what the contents of this document should be, or it's just been presented at this stage as a draft.
I think it has been presented as a draft, but I think the view was the document, as you would see reading the edits, it was by and large, again, a legacy document that quite honestly should have been updated probably decades ago, because it referred to CHESS, to the ASX, to the listing rules, and dates back to when Burswood Limited was a listed public company, which, as we know, ceased almost 20 years ago. So I think that my understanding is that was the main focus of the proposed changes to the Constitution, to address those legacy issues. And I also understand there was no intention to address to change any of the requirements under the state agreement, which might be embodied in that Constitution.
Well, can I just draw your attention to it's a pinpoint 5415 and proposed new article 15.13. Now, I think, again, earlier, in answer to one of my earlier questions, you explained that your view that essentially as a wholly owned subsidiary of Crown Resorts, they report in a consolidated way, act essentially in a consolidated way. What is your understanding of this? First of all, have you discussed this provision with the other directors, and what's your understanding of it, if you have?
I don't recall discussing that particular provision with the other directors. It was probably included in the draft that I saw. At any time when the company is a wholly owned subsidiary of another body corporate, the holding company, each director is authorised to act in the best interests of the holding company, and in doing so will be taken to be acting in good faith for the best interests of the company. Sorry, what's your question?
Well, was there any discussion about it, and what's your understanding of it?
I don't recall any discussion about that clause.
Do you have an understanding of what it means?
I think I do, unless you want to tell me what the understanding is.
What's your understanding of it?
It is a little confusing. Each director is authorised to act in the best interest of the holding company. So basically, if it's saying the directors of the holding company act in the best interest of the holding company, and in doing so, look, I think probably what it's trying to get to, and it may not say it as articulately as it probably should, the interests of Burswood Limited as the licence holder and as the property owner should be totally aligned with that of the holding company. I'm challenged to think of circumstances, and there may be some, but I'm challenged to think of circumstances when something that's not in the best interests of Burswood Limited, being the controlling entity of the Perth operations, if it's in the best interests of Perth, is not in the best interests of the holding company. So that's my view on that.
I want to come back to some structural things in a moment, Mr. Morrison. Before I do, can I take you to paragraph 71 of your statement, where you've indicated what your current understanding of the directors of Burswood Limited are. Are there any proposals to change that composition of which you are aware?
Well, I have become aware in recent times that I think Mr. Bossy will step down from the board, and the three directors, once Mr. Carter is approved, will be Mr. Carter, Ms. Fuster and Mr. McCann.
And so is that at what stage is that? Is it a proposal, or is it a decision that has been made?
Well, I'm not a director of Burswood Limited, and it is a matter for the Burswood board. But I understand discussions have taken place, and I think that is going to unfold.
All right. So is it your understanding that the discussions have taken place at the Burswood Limited Board level?
I don't know if there's certainly been discussions, I believe, with Mr McCann and Mr Carter with Mr Bossy.
To your knowledge, did those discussions include Ms Fuster?
I do not know.
In the current structure, would you agree with me that in effect, Burswood Limited is accountable to Crown Resorts Limited?
I do, being a wholly owned subsidiary.
And would you agree with the proposition that it is not functionally independent of Crown Resorts?
I think from a governance point of view, I think we are mindful of our obligations, and I think the two would work together, and there will be certain functions and decisions that need to be taken by Burswood appropriately in relation to certain matters. But as I've indicated, I think there is alignment between Burswood Limited's interest and CRL's interests.
In terms of the composition of the board, as it is about to be constituted, Mr Carter will be the chair, and he's a director of Crown Resorts Limited.
Yeah.
Mr McCann will be a director, and he's the CEO of Crown Resorts Limited.
Yeah.
And there'll be Ms Fuster, who is the only one of those three who sits outside either Crown Resorts Limited board or management of Crown Resorts. So on any decision involving Burswood Limited, the common director and the CEO can carry the day. Would you agree with that proposition?
If it requires an ordinary resolution, yes. If it requires a special resolution of 75%, it might be somewhat challenging.
No, but any ordinary resolution of the board will be carried by a simple majority of 2/3, correct?
That would seem to be correct, yes.
And so, coming back to my question, functionally, as constituted, would you agree with the proposition that the Burswood Limited board is not independent of Crown Resorts Limited?
Is not independent. I would agree with that, and I don't see why it needs to be independent of Crown Resorts Limited.
I understand that's your view, Mr Morris. Now, can I put a few things to you and just ask you for your view at the conclusion of these things, and whether these considerations have any influence on your view about the structure of the board. So the first consideration I want to put to you is that Burswood Nominees is the holder of the casino licence in Western Australia. And so it is the company within the Crown Resorts structure that owes the obligations to the West Australian government under the legislative framework in Western Australia. The second is that Burswood Nominees is a party to the state agreement with the state of Western Australia, and so it owes obligations under the agreement of contractual nature to the state of Western Australia as well. And the third is, and this is mentioned in your statement, is the current constitution of Burswood Limited that enshrines in it an obligation for it to have its head office in Western Australia. And that's defined by reference to where its central management and control is located. So having regard to those three considerations, do you consider there may be a case for constituting a board either of Burswood nominees as the licensee or its interim parent company, Burswood Limited, with a completely independent board or a majority of independent directors?
No.
Okay, and why do you say no in the context of those three considerations?
Well, Crown Resorts Limited, or its predecessor, purchased Burswood in 2004 for, I think it was 686 million. If the state at the time was concerned that Burswood was such a significant asset that it shouldn't become a wholly owned subsidiary of another company, it could have decided it was such a significant company and not allowed that transaction to proceed. It didn't. It was comfortable, the government of the day was comfortable for Burswood to become a wholly owned subsidiary of another company. And presumably they considered these matters at the time in 2004. I think the other part of that argument is that at Crown Resorts, we're obviously mindful of the licence obligations to the WA government. And even though it is effectively the obligations of a wholly owned subsidiary, it doesn't make those obligations any less onerous on the board of Crown Resorts. So we take them equally seriously as would a board of Burswood nominees. And the same applies to the state agreement. I think, we take the commitments that Burswood has made to the state under the state agreement most seriously. Burswood and Crown Perth is a very, very significant asset to Crown Resorts, and it's important that we seek to act with integrity and manage that asset and manage the relationships with the regulators and the government and whoever oversees that asset and the licence and the properties in WA, that we manage that to the best of our possible ability at the CRL level. The head office is in WA, and I think, central management and control is in WA. But some governance oversight is provided by CRL together with Burswood. And I think, Burswood is the decision maker as holder of the subsidiary companies, Burswood nominees and the property trust, etc. But I think our interests are totally aligned.
I know the report is quite new, and it was tabled yesterday in Parliament in Victoria. It's the report of the Royal Commission to Victoria. Have you had an opportunity to consider some of the recommendations of that report at this stage?
I have.
And are you aware that one of the recommendations is that the Casino Control Act in Victoria be amended to impose an obligation on the casino operator to have a majority of its board as independent directors, including independent of the ultimate holding company?
I am.
Do you have a view about whether that a structure of a similar nature would be appropriate in Western Australia?
Well, I disagree with that structure in Melbourne, and therefore I disagree with that structure in Perth.
And is that for similar reasons to those you gave to the earlier answer to my earlier question about the three considerations I put to you, and whether constituting a board of a majority of independent directors would be an appropriate thing to do?
Sorry, could you repeat the question?
Do you disagree with the position in Victoria for the same reasons you disagreed with my earlier question about constituting the board in WA?
Yes.
Can I ask you just some questions around the conception of what you regard as the director's duties of a company that is a licensee of a casino licence in Western Australia? So you would be familiar with the normal conception that company directors have an obligation to act in the best interest of the company as a whole? I take it?
Mm-hmm.
And in an orthodox setting, that's usually considered to be the shareholders' and members' interests,
Mm-hmm.
and it can take into account creditors or contingent creditor interests. Do you have a view at all about whether the conception of the interests of the company as a whole should or does take into account what might be regarded as community interests or responsibilities of a good corporate citizen?
I think absolutely they should. The casinos need a social licence to operate, and we need to have good corporate governance, and that embraces the community. And licences, casino licences, exclusive casino licences, are a privilege, and we need to make sure that we look after those. They're our most valuable asset, as we are finding in this year of 2021 with the various reports and what's happened to Crown. Those licences are hugely are the only asset we've got at the end of the day. There are some bricks and mortar, but those licences to operate are hugely important, and we need to take care of those assets. And that means we need to develop the right relationships with the regulators, with the governments, and make sure we are upholding standards to the highest level to earn our position to hold those licences. And I think that's what we need to do. And I think that is, I can assure you, that is absolutely at the forefront of the directors of the Crown Resorts Limited, be it Melbourne, be it Sydney, be it Perth.
All right, but in terms of if we put the terms of the responsibility, and then what I mean by just the community of Western Australia that comes with being a licensee of a casino licence in this state, that rests with Burswood nominees, does it not?
I believe so.
And so the directors of Burswood nominees are the ones who owe the duties to the company to discharge that particular obligation, are they not?
Well, I'm not sure about that legalistically. I think in practice and commercially, those obligations are hugely significant obligations, overseen by the holding company. Those obligations are the obligations of a wholly owned subsidiary company. And my understanding is the directors of that company are executive management, which I would put to you is not an unusual situation in any jurisdiction around Australia. And I'd be surprised if Star in relation to Queensland has a different structure vis-a-vis the main Star Entertainment Board. I know Sky City didn't have it. I'm not sure what it does today, but I don't think it does. But, you know, it's quite usual and common practice for those entities, the boards of those entities probably to be populated by executives of the organisation. But the governance oversight, if you like, to some extent is delegated up to Crown Resorts Limited, being the ultimate holding company. And it would make sure that, the management of the directors of Burswood nominees bring matters to the attention. I would imagine it would go Burswood nominees through to Burswood Limited, and then there'd be consultation between Burswood Limited and Crown and discussion, and Burswood Limited would make the ultimate decision.
But what you're in that answer, you're really directing attention to is an indirectness in terms of the responsibility of the directors of Crown Resorts for the discharge of the licensee's obligations in Western Australia through the chain.
Yeah, I think that's correct.
There's no member of the Crown Resorts Board who directly owes those obligations to Burswood nominees, is there?
No member of the Crown. Well, other than the fact that it's one of the most valuable licences we hold, and probably if you sit here today, it's probably the most valuable licence. So I think the Crown Resorts Board takes its obligations of all its subsidiary companies most seriously.
right. Just to try and capture what's been quite a few questions and answers, Mr. Morrison, in a nutshell, are you expressing the view that you don't see there to be any need for independence of the board of either the licensee directly or the interim company that controls it? Because, in your view, due to the nature of the asset, that is to say the casino licence, the obligations owed by the licensee will be discharged through the corporate responsibilities of Crown Resorts as the holding company.
I think that's correct. I think the obligation on the directors of Crown Resorts is to make sure there is a framework to make sure that occurs. And I think, if it needs to be considered at different levels of the organisation, it will be. But I see, as I said, I see Perth as a hugely valuable asset to Crown Resorts and Burswood Limited. And I do see, I would like to think in the near term, we'll have a Perth-based non-executive director on the Crown Resorts board who also sits on the Burswood Limited board, who would join Mr. Carter and Mr. McCann and Ms. Fuster. I think that would be a good model. That hasn't been, I should say, that is my personal view, but I think that would be a good model going forward.
Now, in answer to one of my earlier questions, you explained that, we expressed a view that along the lines of when Burswood Limited became a wholly owned subsidiary of Crown Resorts, the structure was acceptable. I'm putting words in your mouth, but essentially, I'm paraphrasing you, acceptable to the state of West Australia at the time. There was, however, a provision of the Burswood Limited Constitution that became enshrined in it as part of that process that is referred to in your statement, which is Article 3.12. And you have been asked a question about whether you consider that to be being discharged.
Sorry, where is it in my statement? Sorry.
This is at pinpoint 0985. There's a topic 31 and a question number 42.
The head office.
And you've indicated that your understanding of that provision of the article of the Constitution, and that you expressed the view that you think it's been discharged.
Yes.
In practical terms, with the governance structure essentially centralised in Victoria, how do you consider that Burswood Limited is able to comply with that provision of the Constitution?
Well, I think the day-to-day management and decision-making does take place in Perth. The governance structure, as you say, centralised in Victoria, is really, I think to some extent, the provision of shared services to assist. I sort of view it as what I'd call a matrix and matrix management. And the shared service function is there to assist the management of Burswood, of Perth. And it should be held to account as such. And I think by having a shared service function that provides those shared services, if you like, in relation to money laundering and responsible gaming, it allows us to get economies of scale to deliver a better quality solution going forward, which can be devolved and offered to the operations of the three independent companies, the three independent operations. and they would then be well tweaked to meet their specific criteria if required in their various jurisdictions. So I think Lonnie Bossy is the CEO of Burswood, is effectively running Burswood. He does report to Steve McCann. There is a board of Burswood board that he also reports to, and collectively they manage it. And I think then that is based in Perth, and Burswood then if there's any significant issues that need to be considered or need to be considered at the Crown Resorts meeting, they're brought up at the Crown Resorts meeting and discussed and worked through. But at the end of the day, the decision making in relation to those issues would be taken by Burswood Limited, but there would be consultation with Crown Resorts.
In that answer, that you've mentioned management quite a few times. How do you see control being undertaken in Western Australia?
I see Mr. Bossy as the CEO of Crown Perth, effectively, certainly in day-to-day control, and but reporting through to Mr. McCann in relation to being his CEO. When we meet as a Crown Resorts board, Mr. Bossy gives presentations of the results of Burswood, raises a range of issues of Burswood for us to consider, to be informed about, and those things are discussed, and the Crown Board's kept abreast of those. And also, I think now with Mr. Carter being on the board of Burswood nominees and Mr. McCann being on the board of Burswood Limited, I think there'll be not only Mr. Bossy, there'll be the presence of Mr. Carter and Mr. McCann on the Crown Resorts board as well. So I don't really see any issue or detriment as a result of this structure to the successful operation and continued operation of Burswood.
All right, Mr. Morris. Can I just move to a slightly different topic, but remaining in the area of governance, which is the Crown Melbourne Management Agreement. And this is on pinpoint 0986, topic 33 and 34. Now, in paragraph 81, you've outlined your understanding of certain things in the acquisition of Burswood by PBL. What's the source of the understanding you've expressed in that paragraph?
Well, I left Crown in 2000, and I was aware of the single-purpose covenant that applied to Crown Melbourne, or Crown Limited as it was then, and that various concessions needed to be, I'm assuming, needed to be negotiated to allow PBL to then purchase Burswood. And I think that's also covered in Mr. Finkelstein's report in more detail than my commentary here as well. So that's my understanding.
All right. Now, if I understand the way in which you've responded to the questions that are asked here correctly, you've essentially expressed the view that there are a number of advantages to the Crown Group in having multiple properties. And you've also expressed the view that there are certain advantages to Crown Perth itself in having capital spent by the Crown Group on the Perth the Crown Perth site. Is that a fair summary of part of what you're saying in these paragraphs 79 through to 84?
I think that's certainly some of the points. Certainly, having multiple properties, I think, is a key asset. I think it's in many ways the sum of the parts is, the whole is greater than the sum of the parts. And certainly from a customer point of view, I think that applies, and it certainly does in relation to international business. And then there are certain economies of scale which come into effect as well in that regard. And then in relation to capital, if you look at it, Crown or PBL purchased Burswood, I think, for $686 million in 2004, and has spent probably some $1.6 billion since on Perth. And I'm sure you'd agree with me that the Perth property is a very enviable asset today, and is by far superior to the asset that it was back in 2004. Without Crown and its vision and its capital, you wouldn't have Crown Towers today in Perth, and I'm sure you wouldn't have Nobu. Crown Towers is a great asset for Perth, so I think all those sort of things come into play.
All right. Now, without dwelling on it, there may well be advantages to Crown Perth in the short or medium term to having membership of a larger group. But would you agree with me that, leaving aside what views you might have about the prospects of this ever taking place, but would you agree with me that the effect of the clause 33RA is that it precludes operating the Crown Group in a way whereby Crown Perth could ever challenge Crown Melbourne as the preeminent casino site in Australia?
Well, I mean, turning to sublim 2 there, will endeavour to maintain the Melbourne casino as a dominant commission-based play casino in Australia. Now, to my understanding, WA and Crown have agreed that junkets will cease and have ceased. But I also understand that the gaming regulator in Perth has stated it doesn't want to entertain commission-based play in Perth. So if that's the case, and reading the Commissioner's report in Victoria, my take out of his report is that he's comfortable with commission-based play, given that junket players can opt to play commission-based as commission-based players. Then I think that is a decision the gambling regulator has made, or whoever's made it in Perth. So it's not an issue, because effectively WA has opted out of that market. So I think that falls away. The company must ensure that the holding company locates the headquarters of its gaming business in Melbourne. Well, I think the issue here, and it relates to 3, I guess, that the holding company maintains the Melbourne casino as the flagship casino of the holding company's gaming business. When PBL purchased Burswood, as I said, I think it was about, call it 680 to 700 million. At that time, Crown Melbourne probably was worth 3 billion. So I think, and has occurred, 1.6 billion has been spent on Burswood and invested into the Burswood asset, created what is now Crown Perth, which I'm sure you would agree is an amazing facility, has created that asset. And yet, and additional capital has been invested into Melbourne since that time, and the Metropole Hotel and other facilities. So, and I think, also Melbourne obviously does have a bigger population than Perth. It is, rightly or wrongly, a greater gateway to international tourists. Probably not today with the COVID restrictions. Probably will be, but or domestic tourism. But I think that I don't think it's an issue. I think the capitalisation, the money that's been spent on Melbourne, continues to be spent on Melbourne and is significantly ahead of where Perth is at, that there is no impediment to Perth going forward. If the population of Perth at some point outgrows the population of Melbourne, if Perth becomes the key international terminal, key international entry point for Australia, that at some point may become an issue. But I think, unfortunately, those things are probably unlikely. And I think, Melbourne, a city of 5 million people, Crown would continue to invest in Melbourne, but that's not to the detriment of Perth. Crown will continue to invest in Perth and values that asset, very highly. But I think, while that's the case, and the differential in the value of those assets is so great, that for the foreseeable future, Melbourne will remain as the flagship. Although on a per capita basis, perhaps you might argue that Perth is a flagship. But in reality, I think, the company is trying to discharge that obligation.
Let's take Perth out of the equation and hypothesise that Sydney there was a proposition that for the Crown Group as a whole, it would be better to locate the headquarters in Sydney and to make the Sydney property the flagship. And that had benefits, greater benefits for Crown Perth than locating the headquarters and flagship in Melbourne.
I'm not sure why that would have greater benefits for Crown Perth.
I'm just hypothesising. Would that not be a situation in which there's a potential conflict of interest between the interests of Crown Perth?
My personal view is that Melbourne will remain the flagship for the same reason I just articulated regarding Perth. The size, scale, capital investment, the diversity of the operation. Melbourne is a multifaceted, integrated resort, and Perth is, but on a lesser scale, but fitting in size for the community in which it operates. Sydney has some elements of an integrated resort, but it is really a hotel, restaurant, and unfortunately today it doesn't even offer gaming. But even so, its gaming is somewhat restricted. So, while it's a fantastic building and development, I don't think it is a truly integrated resort that would match the quality, which would match the overall facility that Crown Melbourne offers. So I don't think Sydney would be regarded as the flagship of the holding company.
I'm not really asking about the prospect of it taking place, Mr. Morrison. I'm putting to you the proposition that are there not situations that one can conceive of in the future whereby it may be to the advantage of Crown Perth to upset the status quo in terms of having Crown Melbourne as the flagship and headquarters for the Crown Group?
I can't conceptualise any.
What of the clause 21R that refers to the holding group, if it pursues anywhere in Australia a business similar to that of the company, that is Crown Melbourne, so in other words, the Crown Perth business, the holding company will use its best endeavours to ensure that such business is conducted in a manner which is beneficial to that business on the one hand and to the company, Crown Melbourne, on the other, and which promotes tourism, employment and economic development generally in the state of Victoria. Do do you accept the proposition that the agreement with the management agreement in Victoria requires effectively Crown Resorts to operate Crown Perth in a manner whereby it will use its best endeavours effectively to benefit the economy in Victoria?
I think that clause goes on to say, and, which is not detrimental to the company's interests. And I think that's an important clause and an overarching clause, and I think probably today a more significant clause. So if you were to do something, acquire a company that was detrimental to Crown Melbourne, I think you would fall foul of that clause. My understanding is that, and I think this wording dates back some years, and I think there's been a number of revisions to, if you like, the purpose of casinos in more recent times, particularly in Victoria. And that I think it's fair to say in some acts and in some agreements, that particular clause, subclause 1, has been diluted. That no longer today is it as important to the regulators and the state government of Victoria to promote tourism, employment and economic development in the state of Victoria as it is to ensure that you have a casino free of crime and discharging it all of its social and community obligations. And I think if you, I can't take you to it, but if you look at the various agreements that have, and I think Finkelstein in his report, Commissioner Finkelstein, does actually take you through this in that report, how that has changed, and that the focus is on, is more on meeting the standards that society expects today, rather than, if I can put it candidly, purely promoting tourism, employment and economic development. I think that dates back some time, but I think the "and" is very, very important. And to my knowledge, while Crown has continued to do everything that it has done, Crown Resorts, in relation to Perth, I'm not aware of the VCGLR or any regulator or anybody wrapping Crown over the knuckles for developing Crown Perth or Crown Sydney for that matter, and saying, well, you've got this obligation under R1 and that doesn't apply. But the point I tried to make earlier in my response to this is I think the whole, by having 3 facilities, 3 properties, having the whole is greater than the sum of the parts. So the fact that we can offer Crown Towers to Perth and Nobu to Perth is a positive for Melbourne, because when your international tourists come to Perth and experience the standard and the branding, the positioning of Crown Towers and of Nobu, they know what they're going to expect when they come to Melbourne, and they will stay in Crown Towers in Melbourne. So I think, I don't think that is an impediment. I think if it was detrimental, if we were doing something that was detrimental, that would be an issue. But as I said, I think there has been some amelioration or softening of R1 in more recent times, and I'm not aware of anything that we've done in the past ever being regarded as a breach of that clause.
All right, but the clause exists, so there's an obligation of a contractual nature that's owed by Crown Melbourne to the state of Victoria, correct?
I guess the clause exists as you have got it here, yes.
And would you agree with this proposition that it's conceivable, I'm just saying a possibility, it's conceivable that the existence of a contractual obligation of this nature could bring the interests of Crown Perth and those of Crown Melbourne into conflict?
I don't think so. Only if what was being done was detrimental to Melbourne.
All right, let's hypothesise a proposal to carry out some business in Perth at Crown Perth that for some reason will be detrimental to Crown Melbourne. There is then a potential for conflict, is there not, between carrying on that business for the benefit of Crown Perth and potentially Crown Melbourne being in breach of its obligations under the management agreement?
If it was detrimental to Melbourne, I think that would be correct.
And so that's a situation, is not where I think earlier you said you couldn't conceive of there being any circumstance where the interests of Crown Resorts Limited and those of Burswood Limited may not be aligned.
Well, what would be something that would be, if you read the thing in totality, if it pursues anywhere in Australia a similar business to that of the company, Crown Melbourne, will use its best endeavours to ensure. So it already has acquired Crown Perth. That is a historical transaction. That has been done. I think this refers to other transactions. You might argue it relates to Sydney. If Crown was to go and acquire Star in Sydney, this clause may apply. But it does talk about it pursues anywhere in Australia a business. So pursues, I'm interpreting as acquiring another entity, acquiring a similar entity to that of the company, Crown Melbourne. And it has already acquired Crown Perth. And by virtue of the fact that's happened nearly 20 years ago, and I don't think anything untoward has been raised in relation to this clause, I'm assuming that history will continue to prevail.
So, Mr. Morrison, is the way you've answered that question to suggest to me that, so far as you're concerned, now that Crown Perth has been acquired, there cannot be any potential for this clause R 2.1R to operate?
Well, I think, as I said, I think this clause, and look, I should say I'm not a lawyer, but my take out of this clause is this was brought into the agreement at the time when Crown wished to acquire Burswood. My reading of it, if it pursues anywhere in Australia a business similar to that of the company, similar to that of Crown Melbourne. So if it's going to acquire a business similar to Crown Melbourne, it will use its best endeavours to ensure such business is conducted in a manner which is both beneficial to the company and promotes tourism in Victoria, and which is not detrimental to the company's interests. So, perhaps on a second reading, it does look like it does have some sort of continuity. Will use its best endeavours to ensure. So, I guess you could argue that does have continuity. But I think that happens. But I think my interpretation of it is that it hasn't happened. Nobody's objected to it in Victoria in 20 years. It would be more concerned if it was detrimental to Crown Melbourne, but it is hard to envisage when something might be detrimental to Crown Melbourne.
I think I'll move on, Commissioners. Mr. Morrison, can I move to a different topic of remediation? How familiar are you with the remediation plan?
I've read it.
And would you agree with the proposition that it identifies responses to what one might term deficiencies that have been identified in either the Bergen inquiry or some other inquiry to date? Deficiencies in Crown Resorts systems.
I think its origins were clearly out of the Bergen inquiry, and working with ILGA in terms of seeking to become a suitable person to operate the Sydney Casino. So were its origins. And since that time, other elements have been added to it as the company has become aware of other deficiencies, be it through this commission or through this Royal Commission or the Melbourne Royal Commission.
Of the elements of the remediation plan, are there any that you consider to be of critical importance?
No, I think they're all of significant importance, and if they weren't important, they wouldn't be on there. I mean, some are obviously more important than others, and if you want to take me to some, I'm happy to give you my view on the criticality of the importance of the particular item. A lot has been done, in this remediation plan, and I think a lot of the big ones in terms of the changes of the board, departing directors, departing executive management, departing CEOs. A lot has been done, and they are obviously very, very critical initiatives on the road to remediation, and a lot of those have been done. And but there's a lot to do, but it is being worked through.
All right, I'm really asking for your view, Mr. Morrison, on your view of what you consider to be, I think you've mentioned so far already, the changes to the management and directors of the company. Are there any others that, in your view, are of more significance than others and need to be done perhaps with more urgency?
Okay. All right. So the organisation needs to be settled down. Senior management need to be appointed. There needs to be a chief executive of Sydney. There needs to be a chief operating officer of Crown Melbourne appointed. The other gaps in the organisation structure, significant gaps, be they group general managers, group executive general managers, need to be appointed, and that is happening. It's very difficult to move organisations forward unless you've got your organisation structure set and you've got your key management in place. And obviously for the first half of this year, we struggled with that because we didn't have a chief executive. Steve McCann was only recently licensed, so he's now totally on board, which is fantastic. But the key, I think one of the most important things is to get the organisation structure set and get it populated. And obviously we're working to do that, get all those key positions done. They're very critical and very important. From that then is the reassessment of the vision and values of the organisation, or if you like, the purpose and values. And that has been done and worked through the Deloitte Culture Survey, and management taking that on board and working through that and coming up with a new set of values. Recognising the Deloitte Culture Survey is probably now 6 months old. It's quite some time has passed, but the new values have been established and are being rolled out throughout the organisation. So getting the organisation structure correct, and I should have mentioned making sure we populate the board. Right now we only have 3 licensed board directors, so you can imagine for an organisation like Crown, with only 3 licensed board directors, there's an awful lot of work to do. We've had something like 10 meetings in the last 2 weeks. So there's a lot of work to do. So we do need to get, and obviously it takes time to get these people, identify these people, recruit these people, whether board or management level, and then get them to pass probity. But those getting the board right and fulfilling the board, and getting the executive management right and fulfilling the executive management is a huge critical task to be done. And then cascading down and formulating the values and the purpose of the organisation and cascading that through the organisation is absolutely critical. And then at that point we can start to move culture. And communication is absolutely essential. We also need to make sure that we get those risk areas where we've been deficient, and a lot of the remediation plan is devoted to AML and CTF, and I do think we are making good progress in that regard with the team there, and the significant enhancement of resources, the organisation structure under financial crime and compliance, and recruiting top people in that area. That is taking place, and there are still a couple of empty boxes, but we need to get those done, and I think we're making good progress with that. We do need to recruit a new, let me get this right, Group Executive General Manager of Responsible Gaming. That position has been elevated in status, given, I guess, what we would call the deficiencies that we've identified through a range of feedback, and we do need to recruit that. But I understand we are not far away in that appointment, and I think that is an absolutely critical appointment as well. The next thing then that has to come is we have to get our remuneration structure right. You asked me to tell you, and I'm telling you. We have to get our remuneration structure right. And we need to have our incentive compensation correct in terms of its components. So our short-term incentive remuneration needs to be structured properly, along with our longer-term incentive remuneration. And there need to be gates there. You would have heard Crown would have been perceived to have a purpose beyond profit. A profit beyond purpose, and put profit ahead of purpose. And we need to bring that back in, and we need to make sure that from a culture point of view and from an incentive compensation point of view, people are correctly remunerated in terms of their incentive compensation. And I think, that means that there needs to be gatekeepers, that if you need to demonstrate that you have upheld the values of the organisation, the new values, that you live the values, and that you then have a range of non-financial key performance objectives to meet. And unless you meet the values and get through those gatekeeper provisions, you are not eligible for short-term incentive remuneration, and you may not be eligible for long-term incentive remuneration. So you need to get through those gates, and then you're eligible for incentive remuneration. So I think all those things are critical, and I think that goes to culture. It goes to addressing AML and CTF. It goes to addressing responsible gaming, and it goes to populating the management team. I'm a great believer in strategy, structure, staff. Let's set our strategy. We know what our strategy is now, and the non-financial elements that are so important to our social licence are much more important in our strategy going forward. So we need to get our strategy right that leads to our organisation structure. You've seen that with the elevation of such people of the Chief Risk Officer, of the Internal Audit, Executive Manager of Internal Audit, of the Chief Compliance Officer, Financial Crime and Compliance Officer, a splitting of functions between General Counsel and Company Secretary. All those things have been done and elevated in status. And I think, and the new appointment of the Chief People and Culture Officer. So all getting that organisation structure structured to meet the new objectives of the new Crown is so important. And we are significantly down that process. And I think that's hugely important for the organisation. So I think all those things are critical. And I think if we can get that right, if we can get the teams in place, have the board in place, have the management team in place, have the right organisation structure, have the right culture driven by vision and by purpose and values, and then have the right incentive remuneration measures in place, I think we will go a long way to realising our vision of getting Crown back on the right track.
All right, Mr. Morrison, thank you for that answer. In amongst some of the things you said, you mentioned the recruitment. I think you said of an executive RSG manager or something like that. So was that effect? And that there'd been a recognition that you needed to elevate the status of that. When was that decision made?
I think that was made probably, I'm guessing, a couple of months ago. Where are we now? September, probably 6 weeks ago.
And was that a decision made at the Crown Resorts Limited board level, or was it a management decision?
It was a management decision.
And you became aware of it through what mechanism?
through reporting back to the board in an update session, I guess, yeah.
I see.
That's CRL.
I see. I've got a couple more questions for you on the remediation plan, Mr. Marshall. I would ask if perhaps in answer to these ones you could try and confine your answer somewhat, and if we need more, I'll ask you more questions. Do you have any concerns about the scope or adequacy of the remediation plan?
I don't think so, other than it's a living document and it will continue to be improved.
All right. Do you have any concerns about the ability of the senior executive team to deliver the plan?
Well, as I think I mentioned in my slightly longer answer, we need to get the organisation structure set, and we need to populate it. We haven't populated all the positions yet, so we do need to do that, and then we will have an able senior executive team to fulfil all those functions.
I see. So I'm drawing a bit of a distinction perhaps between the very top level executives and perhaps the next layer down. Are you suggesting that essentially the core team still needs to be completed?
Well, I think the top level reporting to the CEO is probably complete. But that next level down, which is very, very important and still very, very senior people, there are still some vacancies there that need to be populated.
And I expect that the filling of those vacancies is in the area of responsibility of Mr. McCann, I presume.
I would have thought so, yes. And through, if you like, probably Mr. Blackburn in relation to those that report to him in terms of financial crime and compliance, and in this case, responsible gaming as well. But no doubt Mr. McCann will have oversight of those appointments.
Can I just? I'd like to ask you just some general questions that arise out of some of the answers your paragraphs in your statement that address sort of process within the organisation, and really what I'm interested in is understanding how information about risk, in your experience, has been brought to the attention of the Crown Resorts Board. So in paragraphs 36, 41, 42 and 43 of your statement, you have indicated effectively four things I'm going to put to you, and if I get them wrong, you'll no doubt correct me. In those paragraphs, you indicate that significant business risks are reported to the Crown Resorts Board through the Risk Management Committee, and there's a reference to that in paragraph 36. You indicate that the Risk Management Committee and the Audit and Governance Committee are keys to effective oversight of risk management, and you make reference to that in paragraph 41. You indicate that information is fed through the committees to the board in paragraph 42, and you indicate that significant risks are escalated to the board in paragraph 43. And what I'd like to do with each of those is ask you, in practical terms, how that reporting takes place. So, for example, are you able to give us a sense of what significant business risks have been identified since you've been on the board of Crown Resorts, have been identified by the Risk Management Committee and reported to the Crown Resorts Board?
Can I give you one in relation to the Audit and Risk Committee? Audit and Governance Committee?
Yes.
So one that comes to mind would be the understanding of the, I suppose there's a number of factors, but the fact that the going concern opinion of the auditor was going to be, if you like, to some extent qualified. And there was significant uncertainty that related to the going concern of Crown Resorts by virtue of the position that Crown found itself in terms of primarily COVID-19, but also the significant uncertainty arising out of the various inquiries in Bergen, etc. So that was raised at the Audit and Risk Committee and identified, it is a risk and considered at the Audit and Risk Committee. And then it was elevated to the Crown Board, and the Audit and Risk Committee referred that to the Crown Board, and the board considered it and had discussions with the external auditor, KPMG, and understood what the issues were and why it was saying that. But that was one recent issue that comes to mind of how factors flow through the various boards.
All right.
The subcommittee board.
The mechanism for bringing it to the board's attention from the Audit and Governance Committee, what was the mechanism? Is that a paper and delivered by the chair, or how was it brought to attention?
Yeah, there would be papers. There would be papers presented to the Audit and Risk Committee. There would be minutes of the Audit and Risk Committee. And if the Audit and Risk Committee considered the matter to be of sufficient note, those committee papers would be available to members of the Crown Resorts Board. Then those papers would be represented to the Crown Resorts Board, and a similar discussion would take place with the opportunity for the Crown Resorts directors to raise the issue and discuss the issue with the personnel who raised it to the Audit and Risk Committee.
Okay, now, can I ask you, can I direct your attention to paragraph 43? And are you, in that paragraph, giving an explanation of examples where risks of the kind described in paragraphs A through to K have in fact been brought to the board's attention, or are you describing the ideal, as in what you would expect to take place?
Let me just review them, but I think they are instances. A is real, B is real, C is real, D is real, E is real, health and safety issues are real, COVID-19 is real, remuneration policies and organisation structures real, material litigations unfortunately real, divestment of assets is real, appointment of they're all real. Okay.
And what I noticed doesn't appear on that list is RSG.
Yep, that's probably my oversight.
So have there been examples of responsible service of gaming risks that have been brought to the attention of the board during your tenure?
Absolutely. And one example would be moving to the 12-hour play periods. Went to the responsible service of gaming subcommittee and went to the board.
And indeed, when you're describing AML CTF risks, is that a shorthand for something bigger, or is it just referring there to money laundering and terrorism financing risks?
There's a generic comment to all things that are embraced in that. It could be the China Union Pay. It could be progress we're making with ILGA. It could be progress we're making with, system enhancements. It could be progress with our risk management approach. We've got quite an ambitious plan to address AML and CTF issues at Crown, and reporting back as to meeting the timeframes and timelines is very important. So in that sense, it was a generic heading.
Thank you, Mr. Morrison. Commissioners, would you think this might be a time to give the transcribers a break?
I believe that's appropriate. Mr. Morrison, for the benefit of our transcribers, we need to take a break, so we will 10 minutes. We'll break for 10 minutes. So, are you in? I presume you're in either Melbourne or Sydney, just for the time.
I'm in Melbourne. It's 7 o'clock.
So we'll come back at 7:10 your time, 4:10 real time.
Thank you, Commissioner.
Guys.
Please be seated. Thank you, Mr Morrison. Mr Futrell.
Mate, please. Mr Morrison, do you still have your statement somewhere on the table in front of you?
I do.
Can I ask you to find topic 37 on the pinpoint is 0989 as a heading culture. And you've dealt with this in a number of paragraphs. The first, in 88, you mentioned that the corporate culture of the Crown Group is very good, but it reflects substantial recent changes. Then in 89, you make reference to it being satisfactory and appropriate for its operations. What do you mean putting those two together? Is it good and satisfactory, or is it they may mean different things?
Yeah. I guess to some extent, my view on the culture is mirrored by the interactions I've had recently with executive members of the team. I do think the culture at Crown is very good, I've got to say, and I do think it is satisfactory and appropriate for its operations. But I think it can be improved, and as we drill down into it, there will be pockets in the organisation that need to be focused on and need to be improved. And the surveys that we have done and will continue to do will help us identify those areas that need to be improved, identify the issues in those areas, and we'll remeasure them and make sure we do improve them. And address changes that need to be made in those pockets in the organisation. But I must say I've been very impressed with the changes that have taken place in Melbourne, with the acting Chief Operating Officer there, Peter Crinnis, and the executive team that reports to him, and have met with them. And I think the calibre of those people, and that's in this pocket of Crown Melbourne, I think they're very, very good, and I'm comforted by that. And I think as I walk around the property in Melbourne, and unfortunately I haven't been able to go to Perth, but I meet the people as I'm walking around the property in Melbourne, and I think Crown has always had an outstanding focus on customer service. And, that is something that is actually very hard to train, but that is instilled in the organisation, but perhaps a little bit maybe to its detriment. And we just need to rebalance it and centre it. But I think by and large, the corporate culture in the organisation is very good.
The view that you've expressed about the corporate culture, have you read the Deloitte Culture Report?
Yes, I have.
Has your view...
I've actually got a copy of it.
All right.
If you wouldn't mind, if I just...
Yeah, perhaps the number in the top right-hand corner should be CRW 0.701.004.9441. I just want to understand whether your view that you're expressing about the culture is in any way influenced by that particular report or the surveys in the report.
Look, I think it is to some extent. I'd like to draw your attention to the context in which that report was done and the time at which it was done. And if you turn to, .9447, it refers to the context. And it says, this review has been undertaken during a particularly volatile time for Crown, influenced by COVID-19, including shutdowns and labour shortages, public scrutiny involving inquiries and royal commissions, change in leadership at the board and executive levels, and potential takeover bids by other organisations. These factors may have influenced employees' perceptions of the organisational culture and thus the findings of this review. And to be honest with you, that's the second paragraph of this report effectively. And my personal view is they have certainly impacted this review. And if you look at the time at which when the survey was taking place, it was effectively on average the end of April, and that today is now some 6 months old. So, and that, you know, back then it was right in the hiatus of the media storm, right in the hiatus of COVID and the uncertainty, JobKeeper, what was happening with that, properties being closed. And I met with a number of staff and management around that time, and potential takeover bid was a huge issue for people. You know, that's a very scary proposition about job security. So I think look, this provides some very helpful information, and it's a starting point. And my experience with these customer surveys, staff surveys and culture reviews is they're a line in the sand, and you hope to improve from them. Now, I haven't seen the information that is drilled down from this report into individual pockets in the organisation, but I would expect that will help our management team work out where the weaknesses are and how they need to be addressed, and what the real issues are that cause people to have those views.
When you've said in paragraph 92 of your statement, you generally agree with the observations set out in the review. I'm trying to understand what you take from this, because the context that is described there, it may in part explain the overarching findings to a degree, but the overarching findings, would you not agree with me, overall are quite alarming in terms of the culture of Crown Resorts?
I think they're challenging, but I think you've got to take it with that context, and I think more work needs to be done on driving down to individual pockets. You know, I would say to you, casino businesses are not like your normal office job. They are not 9 to 5 jobs. They are 365 days a year usually, 7 days a week, 24 hours a day. And people work on rotational shifts, and it's very challenging. There's a whole range of other impediments in organisations like casinos that cause people to be disenfranchised with their roles and with their jobs. It's very hard for, if you like, dealers who have been with an organisation many years and been remunerated and continue to receive such high levels of pay that they actually may not enjoy their job, but they're paid relatively so highly that they can't go and work anywhere else because they'd have to take a pay cut. So there's a whole range of factors, and I think, as I said, this is a line in the sand. It's a great first start and benchmark, but I also think that the findings were 6 months old, and my views are more current. And I think since this was taken, there's been the appointment of a CEO, there's been a population of an organisation chart with a lot of senior people trying and doing a lot of work very well. You've had the new board, you've had changes of the boards in that time. You've had the identification of the chairman-elect, and you know, a range of things are happening. And I think, you know, the takeover bids have fallen away, and there is now a roadmap out of COVID. So I think you know, a lot of things have changed. Some within our control and some not within our control, but I think we're heading in the right direction. And I think if you did this survey today, which is 6 months from when it was done previously, I would hope the results are better. But when we come to do it, probably in a 12-month time frame, I would certainly expect the results to be better.
You're not suggesting, though, that things have been turned around in 12 months, in 6 months, are you?
Absolutely. I think big steps can be made. And 6 months is a long period of time. You know, a lot of work, and we won't know, to be honest with you, until this has been done. If you think what's happened in 6 months, a lot has happened in 6 months. An inordinate amount has happened in 6 months. And I'd be surprised if we haven't made good progress. I think the communication the organisation is doing now to its management and its staff is far superior than a year ago. Steve McCann is recording videos and speaking to people. If it wasn't for COVID, he'd be here in Melbourne, he'd be here in Perth. A lot of people are making an effort to communicate with staff. The feedback from staff is communication is much better. Directors have more of a presence with the management of the organisation, with the senior managers. We meet informally with the management of the organisation. So I think a lot has been achieved, and I think the findings, the culture today would be better than it was when this survey was done. And look, to be honest with you, that's my experience. You can move culture, and if you do the right things, you can move it. In a good period of time.
You've indicated that, I mean, this is reflected in paragraph 93 of your statement, that the culture has already changed, and you indicate that culture is driven from the top.
Yep.
Would you agree with the proposition that for cultural change to take place, it's necessary that it occur at all levels in the organisation?
It has to start at the top, and it has to be driven from the top, and it needs continual reinforcement from the top. And by the top, I mean the top of the organisation, the board, the CEO, the direct reports to the CEO, and certainly the next level down. They're very, very important people. And the communication to staff, and it's very, very important that the top actually get out and talk to the staff and talk to staff members at the coalface, at the customer face. It does, and I think that changes culture.
To your knowledge, is there any part of the remediation plan of which you're aware that will include a component of renewal or refreshment of middle management?
To my knowledge, not as a holistic initiative. I don't think we need to have a line that says, I don't think it's there, that says to refresh middle management. I think we need to look at it on a case-by-case basis, and I think the survey report by Deloitte, it will be very good for identifying certain weaknesses in some of our managers, which we will need to address. And I'm sure Steve McCann and Tony Weston will work through that and work out how we help those people improve and get them up to standard. But I think a key point there is, the management of this organisation. If you go back a year ago or 2 years ago, when the core issues were prevalent, that management is gone. And what you have, I think, is by and large an appropriately, motivated team looking for leadership and looking for the right leadership. Now, we change that message from the top, and I think those people will embrace the new message. Now, there'll be some that won't, and some that we will need to make change with. But by and large, I don't think there's a holistic initiative to replace half of middle management.
I'm not suggesting that perhaps they all need to be replaced, Mr. Morrison, but if you've read the culture report carefully, if you read paragraph the page 9477, for example.
9477.
The last 4 digits.
We act respectfully. Yes, what would you like to?
Deeper insights. Left-hand column, last paragraph. Examples of poor behaviour from executives and general managers include lack of consultation, being ignored on the job, rudeness, bullying and favouritism. Others cited a lack of visibility of senior management and fluctuating moods, and felt that senior management do not care about staff members' opinions. Top of the next column, middle and senior management were also perceived to have low engagement with employees and or negative apathetic approaches to frontline staff and so forth.
And the question is? Well,
you indicated that you think that there's already been cultural change. Are you suggesting there's been cultural change of this nature?
In part, we're not there. We're clearly not there, and Tony Weston has his culture change program that he's rolling out. But if I take your point, poor executives and general managers, lack of consultation, you know, I think culture in many ways is a mirror, and you tend to behave in a manner that's not dissimilar to the way you were treated. So if that's happening at the top and cascading down onto executives and general managers, then they are more than likely to behave in the same manner. So what we have tried to do and are doing is changing it at the top, and we are making it clear to those executives and general managers that we would expect them to address these issues, that they should be more consultative, so that they're not being ignored on the job, so they're not rude, they're not bullying, definitely not bullying. We have no tolerance for bullying, and that favouritism is removed. And those things, as I say, when we distill those things and find out where they're actually occurring, we can actually manage those things. But I think if we, you know, they're probably sentiments that those executives and general managers perhaps felt they were the subject of as well, and replicated that behaviour. So we fixed that behaviour at the top, and I would hope that that would cascade through the organisation. And I can tell you from my dealings with the senior executive team and the executive team, say, in Crown Melbourne, I think we have a good core group of people who I think embody good values.
You have referred in paragraph, just need to find it. To your paragraph 90, sorry. You've expressed the view that some confidence in Mr. Bossy, and that he will establish a diligent, appropriate and positive culture within his team. And there you're referring to Crown Perth, I take it.
That's correct.
And what is it about your interactions with Mr. Bossy that have provided you with that level of confidence?
Well, I've known him intermittently over many years. When I was the Chief Operating Officer of Crown in Melbourne, he joined the, I believe, the Gaming Machines division, reporting to Rowan Craigie, and worked with Rowan. And as you know, Rowan went on to be the CEO of Crown Melbourne. Lonnie was always identified back then in my time as a young executive with outstanding capability. And I think, you know, he's gone on to demonstrate that. He spent some time in the USA working on major transactions in the USA and got some international expertise over there. You know, he was respected enough to be sent over to the USA to do that. He came back and he's now worked his way up to running Perth. I know when I was at Sky City, when I was the managing director of Sky City, I tried a couple of times to poach Lonnie to join Sky City, but he was very, very happy at Crown and with his career, and enjoyed working for Crown. And I couldn't persuade him to leave. So I have a lot of respect for Lonnie. I think he's an excellent calibre person.
Have you had any more recent experience with Mr. Bossy that you were basing your views on, or is this from a previous time?
No, I've had a number of discussions with Mr. Bossy. He presents to the Crown Limited Board when he's talking about Crown Perth matters, and I've probably seen him present probably 3 or 4 times to the Crown Limited Board on the results of Perth, on initiatives that he wants to take in Crown Perth, on the development of the responsible gaming centre in Crown Perth. I've had a number of phone calls with him personally, getting updates on a range of issues. And I know Mr. Carter has had quite a good dialogue with him in recent times in his visits to Crown Perth.
I've no further questions.
Thank you, Mr. Futrell. Do we have anyone offline or online or someone? Are there any applications from the room?
Yes, if I may, Commissioner.
Mr. Power.
Thank you. Mr. Morrison, I appear for Morena Fuster, and I have a few questions for you about your statement, which I think you still have in front of you.
Yes.
Okay. Your first official board meeting, as you describe it, at the Crown Resorts Board was on the 15th of April this year.
I think that's what it says. That would be correct.
It does say at paragraph 20. I want you to look at
Paragraph. Yes, thank you.
Would you look at paragraph 48 for me, please? That's on page 11 of the statement. The printed reference is CRW 998-002-0979. Just take a moment to read that if you wish.
Yes.
There you speak about the Crown Resorts Board meeting with extreme frequency. So since the 15th of April this year, how many times has that board met to deal with the issues which you describe in paragraph 47?
Which I describe in paragraph
47, the immediately preceding.
47.
Yes.
I couldn't tell you the answer to that. I can tell you in the last 2 weeks, we've had probably 10 meetings, 10 meetings of various sorts. I would expect we certainly would probably meet at least twice a week. For a while there, we were meeting every Sunday afternoon with receiving papers on a Saturday. So it has been a very challenging time, and particularly now, with a small group of directors and dealing with all the issues that we've been dealing with.
And have you found that your attendance at those meetings have first of all been informative for you?
Yes.
And helpful?
Yes.
And are you aware that in this year, the Burswood Limited Board has met just 3 times in April, June and August?
I probably should have known that, but it doesn't come to mind.
Do you know the next scheduled meeting of the Burswood Limited Board is set for the 10th of December this year?
Right.
Did you know that?
I could, if you'd have asked me that question, I couldn't have given you that date.
Do you think it would have been helpful for the Burswood Limited Board to have met, if not as frequently as the Board of Crown Resorts, to discuss the issues that you referred to in paragraph number 47, to at least have met more than 3 times this year so that Ms. Fuster would be better informed?
I would think that's a reasonable proposition, yes.
I have no further questions.
Thank you, Mr. Power. Any other applications? No.
No questions.
I've only got one. That is in respect of the senior management of Perth Casino. In your opinion, should they report to and take instructions from the Burswood Limited Board, or ultimately through CRL or group managers to the CRL board?
So I would have thought the Burswood Limited management should take instructions from the CEO of Burswood, being Lonnie Bossy. And
he should be answerable to Burswood Limited Board or to...
Well, I think both. Both.
So in respect to Commissioner Finkelstein's recommendation that the senior members of the Melbourne Casino executive should only be answerable to the Melbourne Casino Board. You would disagree with that recommendation?
I would.
And for the same reasons that you've given in respect to when answering questions about his recommendation that the board of Melbourne Casino should be entirely independent from CRL.
Yes.
Thank you, Mr. Morrison.
Thank you. Mr. Morrison, I also have only one question, and I want to take you back to your time at Sky City. You were the CEO of Sky City Entertainment Group Limited. You said there was a subsidiary in Adelaide, but I thought I heard you say there was a group in Adelaide. Is that right? Was there more than one company in the Sky City Adelaide subgroup?
I would expect there almost certainly would be, Commissioner, but I can't recall. But just as I guess we think of Perth as Perth or Burswood, we thought of Adelaide as Adelaide, that I'm sure there would be a number of companies there as well.
So you probably can't answer my next question, which is that if you regard the Burswood subgroup, you've got Burswood Limited as the most important company in governance terms, so in operational governance terms, but you've got a separate company, Burswood Nominees, holding the licence. Are you able to tell me whether that was the same situation in the Sky City Group in Adelaide at the time?
I'm sorry, I can't. I can't. No, I don't know.
Ms Thornton?
No questions in this.
Thank you.
examination.
Mr Morrison, thank you very much for making yourself available to us and for your evidence. It has been of assistance and we're very grateful to you. Because the situation is evolving, I think we will leave the summons in place. I won't discharge it, but I doubt that we'd need to speak to you again, but just in case, I'll leave the summons in place. You'll be advised as soon as we can when the summons is discharged. But again, thank you very much. And
Thank you, Commissioner.
resume
Thank you very much.
your more normal activities. And we will now adjourn until Friday the 29th of October at 6:30 a.m. Perth time. Thank you.